Hi there. Today I want to tell you all about a new case, and this case is about vaccine mandates. Now, the mandates for COVID vaccines are pretty much over, but litigation over those mandates isn't. Not only do we have our own appeal in a vaccine mandate case in British Columbia that's being heard this October, but there are other cases being decided right now that are going to help our case, including a victory for freedom in medical choice in a recent decision by the Military Grievance External Review Committee. The decision is written by Nina Frid, and she found that the policy of mandatory vaccines in the Canadian Armed Forces was unconstitutional. This is a really big deal, and I can't wait to tell you all about it. If you're new here, welcome. My name is Christine, and I'm the litigation director with the Canadian Constitution Foundation, a legal charity that fights for fundamental freedoms in Canada. I upload regular videos about our ongoing cases and about other interesting developments in constitutional law in Canada. So if that sounds like something you'd be interested in, please hit like and subscribe below. It really helps my videos out a lot. And I know a lot of you watch these videos without subscribing. Thank you so much for doing that. But remember that subscribing to the channel actually is a zero cost way that you can help our work at the Canadian Constitution Foundation. So please consider hitting that subscription button. So I am excited to tell you about this decision from the Military Grievance External Review Committee about vaccine mandates in the Canadian military. And my new colleague, Josh DeHaas, has written about this case in an op-ed that will be coming out soon. I'm going to link to that in the description below once it is out. Now, the Military Grievance External Review Committee, you've probably never heard of it. It is an independent administrative tribunal, and it reviews military grievances and provides findings and recommendations for the Chief of Defense Staff and the Canadian Armed Forces members who submit grievances to this committee. Now, these tribunals are not courts. They don't have the same precedential value as courts, so courts don't rely on these decisions, but it's still a really important case, even if it's not going to be relied on by courts, because there are so few cases where policies like this were found to violate our Constitution, or where people hurt by mandates were actually able to hold to account the people who imposed these policies. So the committee heard this case because they received numerous grievances from members of the Canadian Armed Forces over the mandatory vaccination policy. Now, you might not remember all of the things that happened during the pandemic, so let's go back in time to that pretty awful time so we actually remember what was happening during this time. On October 8th of 2021, the first directive on COVID vaccines and mandatory vaccines in the armed forces, that's when it was issued. Mandatory vaccination was introduced as a requirement for all Canadian Armed Forces members to perform work-related duties. And the directive on mandatory vaccines for the military stated that accommodation under the Canada Human Rights Act for individuals who were not able to be vaccinated should not be punitive and should be provided up to the point of undue hardship. And this is how a lot of employers treated this. The directive provided that accommodation measures should include things like remote and telework, virtual work, and if it was operationally feasible, as well as combining that with COVID testing in the workplace as an alternative, and alternative workplaces and alternative work schedules. But then, just about a month later, on November 3rd of 2021, a second directive on COVID-19 vaccination for the Canadian Armed Forces was issued. And it set out the requirements for requesting an exemption or accommodation on medical, religious, or other protected grounds of discrimination. And this is called Directive 002. And this new directive stated that adherence to the policy was an expected behavior applicable to Canadian Armed Forces members, to all Armed Forces members, and that those who do not comply are considered to be in breach of Department of Defense and Armed Forces Code of Values and Ethics. It provided, this second directive provided that unvaccinated members of the armed forces unless exempted for operational reasons or accommodated where feasible, that they would not be employed or undergo training on Navy vessels, on Air Force, on aircraft, on Canadian Army fighting or field vehicles, that they would not be posted outside of Canada or deployed on international or domestic operations, or even participate in in-person collective training. Directive 2 emphasized the chain of command's obligation to initiate administrative action against members who refused vaccination or who refused to disclose their vaccination status. Armed Forces members who had not complied or who were not complying were placed on a recorded warning and counseling and probation for misconduct for a period of 14 days to allow them to quote, overcome their conduct deficiency by getting vaccinated. And members who remained unwilling to be vaccinated would then be subject to administrative action. Directive 2 explained that members could not request leave without pay and clarified that it also applied to Armed Forces members who were already authorized to work remotely. So it still required Armed Forces members to go and get vaccinated even if they were already on remote work. Now, another month later, on December 22nd of 2021, an amendment to Directive 2 was issued. And that amendment stated that unvaccinated members could elect to initiate a release on a voluntary basis or a transfer to the supplemental reserve, the military reserves. These members were not exempt from remedial measures until they were released from the armed forces. It also applied to members of the armed forces who were on periods of retention or were undertaking vocational rehabilitation programs for serving members. And the directive stated that unvaccinated members in those situations were not exempt from remedial measures and administrative review for noncompliance with the Armed Forces vaccination policy, and they could see their release from the Armed Forces actually be expedited. Now, what happened was members of the Armed Forces who were experiencing discipline action, essentially, for their failure to get vaccinated or their refusal to disclose whether or not they were vaccinated, they made grievances about these policies. The first directive, the second directive, and then the amendments to the second directive. And the committee reviewed the constitutionality of those directives, even though they really were no longer in force. But when the committee was reviewing this, the consequences of those policies when they were in force was still applicable. And many members were facing the administrative consequences for their refusal to vaccinate. Now, what's fascinating about this decision is that the grievance committee actually found that the policy violated the Constitution. The decision was written by, as I said, Nina Frid, and she found that the policy was unconstitutional. She explained that policies that force people to choose between staying unvaccinated or keeping their jobs engage the charter-protected right to liberty, which includes the right to direct your own medical care. And it also engages security of person, which protects bodily integrity. She found that these violations were not in accordance with the principles of fundamental justice because in some aspects, the policies were arbitrary, overly broad, and disproportionate. So she concluded that their rights protected under Section 7 of the Charter were infringed. Now, as I've talked about before on this channel, it is not enough for there to be an infringement of rights. That right also must be infringed in a way that is not demonstrably justified in a free and democratic society. That's in Section 1 of the Charter. And in a lot of cases that we deal with, this is where the government succeeds. The courts find that the government's limit to our right was justified, but not in this case. Frid wrote that the obligation to limit fundamental rights only when necessary and within proportionate limits, that obligation rests with the armed forces. It was the armed forces that had the obligation to ensure that these mandatory vaccine policies that could result in the release, the kicking out of armed forces members from the military, that policy was minimally impairing. It was on the armed forces to show that there was nothing short of kicking these members out of the military for failing to be vaccinated that could have achieved their goals. And Frid wrote that similar to the duty to accommodate, minimal impairment requires the armed forces to demonstrate that among the range of reasonable alternatives, there is no other less impairing way of achieving the objective in a real and substantial manner. And she finished by saying that the armed forces did not meet that obligation to find that the decision to kick these members out of the military was minimally impairing. As a result, the committee declared the mandatory vaccine policy invalid. And, you might be asking what this achieves, since the policy was no longer in force by the time this was heard. Well, as I said, there were actions taken against some unvaccinated members of the military that were proceeding. Some had been kicked out of the military. So for those members, the committee wrote that all administrative action taken against members as a result of those policies, so all administrative penalties imposed on armed forces members who had not been vaccinated, that they should be rescinded. So some members were at the stage of discipline where they'd already been discharged. Some had quit because of this policy, and a large number had not been disciplined by the time the policy changed. So they were okay. But the result is that the committee decision had an impact on the members of the armed forces who were being hurt or had been hurt by this policy. And that is a really big deal. And it's an anomaly in litigation over vaccine mandates against the government. One thing that really stood out about this case was that it called out this notion that no one is ever forced to get vaccinated. Now, we can go back in time again and think about that period before policies were imposed for public service or for planes and trains or for the military. Just a few months before they were actually brought into force in January of 2021, Prime Minister Trudeau, he actually ruled out the possibility of vaccine mandates, and he called it an extreme measure that could have divisive impacts. Well, I think that it actually did. He shot down the idea again in March of 2021, citing equity and the potential for discrimination. And then of May of that year, he said again, we are not a country that makes vaccination mandatory. But by August of the same year, he made an abrupt U-turn. He announced mandatory vaccinations as a policy requirement for public servants and to board planes and trains. And the military imposed this policy that we were discussing in this case and that was considered by the tribunal in this case. And then after imposing all of this, he called a snap election. It seemed like the Liberals, the government here, had made a calculated decision that they could capitalize on the anger that vaccinated Canadians felt towards unvaccinated Canadians by basically supporting vaccine mandates at a time when, at the time, the Conservative Party had leader Aaron O'Toole, and he was saying that vaccination is a personal health decision. Well, apparently it was important for the Liberal government to take the opposite approach and say vaccination is mandatory and impose it in all types of different scenarios. And then once he was back in power, Trudeau was no longer concerned with equity or divisiveness, and he mused on TV about whether we should even tolerate these extremists, these misogynists and racists who were in the unvaccinated population. Then, when the pandemic kind of subsided, Trudeau changed his tune again, and he claimed that he never forced anyone to get vaccinated. Well, what I like about this tribunal decision is that it kind of calls out this notion, and it pushes back on the idea that no one was forced. While service members and armed forces members theoretically retained a choice, the consequences of a refusal were that the choice is not really a choice. And that's the wording of Frid, who wrote this decision. She explained that the policies that force people to choose between staying unvaccinated and keeping their jobs engage charter-protected rights to liberty, which includes the right to direct your own medical care, and it engages security of person, which protects bodily integrity. And I think Frid is correct. Judges that upheld vaccine mandates, they were wrong to accept the argument that requiring someone to choose between vaccination and severe consequences like termination from your role in the military, to find that that didn't interfere with their rights. Frid's decision It actually makes me a little optimistic that more judges might start to see how bad an argument that was and how binding Supreme Court precedents actually require them to conclude that Section 7 charter rights were engaged. Maybe, for example, in the appeal of our case in British Columbia challenging the provincial vaccine mandates for failing to accommodate medical exemptions, this case could provide, while not binding precedent, some useful guidance. You can stay up to date on that case in British Columbia, which is being heard at the Court of Appeal in October of 2023. You can stay up to date about that case and about all of our other cases by subscribing to our email freedom updates at theccf.ca/freedom updates and by subscribing to this channel and ringing the notification bell so that you never miss an update. Okay, that's all for this update. Thanks for watching, and let's keep fighting for freedom in Canada.